Hi there, how are you today? My name is Conrad Mutiawa, and I'm a lawyer by profession, and I'm also a private law tutor. So basically today we're going to be looking at criminal law, and specifically we're going to be looking at the offense of assault, and that is criminal assault. But before we go on into our class, I encourage you to subscribe to my channel. Just down there, just click on that red subscription button. Also ensure that you like and share this video with your friends, and also turn on your notification so that you're always able to get these videos whenever they are released. And also for those students that are struggling, please, you can always contact us for private law sessions so that we are able to polish you, and you can always find our contact down in the description bar. So let's proceed to look at what this video will be looking at today. So one, in today's class, we're going to be looking at the definition of assault. So we'll look at the definition of assault in detail. Then we'll also proceed to look at the ingredients of the offense of assault. Then, of course, we'll also look at the law providing for the offense of assault. And of course, we'll also look at the actus reus and the mens rea of the offense of assault. And then, of course, in that discussion, we'll also be doing a legal analysis and looking at the various legal principles governing this offense. And of course, we'll also be analyzing a number of cases and what they have held generally on the offense of assault. So ladies and gentlemen, for purposes of the definition of assault, basically an assault is an act by which the accused intentionally or recklessly causes the complainant to apprehend or that action that brings fear in the other party to the immediate and lawful force or violence. So basically, if an act is committed by the other party against you, and that act raises or creates or brings about that fear in the person of the party upon whom such an action is directed to, then definitely that action in law is said to amount to an assault. It's important to note at this juncture, and rightly so, many students normally confuse assault and battery, whereas the two are really very related, but they are actually different, because for battery, there must be a physical contact, but for assault, there need not be any physical contact. The bodies, there must not be that physical contact onto the body, and that is the main distinguishing feature between the two. Of course, also the laws that provide for assault and battery are different, but we'll be looking at that in another class. For today, we are concentrating on assault. So let's proceed, ladies and gentlemen, to look at the ingredients of this offense. But before we look at the ingredients, it's very, very important to point out the law that provides for assault. When you look under the Penal Code Act, under specifically Section 235 of the Penal Code Act of Uganda, it provides for the offense of assault. And actually the punishment for the offense of assault is also stated under that law, which is actually 1 year in imprisonment. The section is very clear, and it states that a person who unlawfully assaults another commits a misdemeanor and is liable to imprisonment for 1 year. So that's the punishment and that's the law. So let's proceed now to look at the ingredients of the offense of criminal assault. So the first ingredient is that the act must amount to an assault. Okay? Then secondly, the assault must be unlawful. It must be prohibited by the law. And of course, we have already seen that it's prohibited by Section 235 of the Penal Code Act of Uganda. And then the third ingredient is that the accused must have occasioned this act. Very, very important. We must always put the accused person onto the scene of crime. He must be the party who has actually occasioned the act. So let's proceed to look definitely at the actus reus and the mens rea of the offense of assault. So for the actus reus, as you remember, actus reus of course means a guilty act, or any criminal act is what amounts or is meant by an actus reus. An actus reus is the guilty act. So let's proceed now to look at the actus reus of the offense of assault. So basically, the actus reus, this consists of any act which makes the victim apprehend or cause that fear that we have just talked about, that unlawful force is about to be inflicted onto their body or their person. Now, no force needs to actually be inflicted directly on a party for you to say that there has been that assault. Okay, so with assault here, there needn't be the physical touch. Okay, even if there is not that physical contact, assault can still be tenable under the law. Okay, this is very important to note from the onset. And some of the actions really that can amount to the actus reus of assault, or some of the actions that can amount to an assault, include very basic things such as raising a fist and you charge against someone, things such as pointing a gun at someone. It is immaterial whether actually the gun has bullets or not. Words that can cause the victim, even words can amount to an assault if you use certain words, provided it can be proved that such words caused fear into the person of the other, then definitely that can amount to an assault. I invite you to look at the case of R versus Constanza. It's a case of 1997, Criminal Law Reports, page 576. In this case, basically, court held that silent phone calls would actually amount to an assault. Just calling someone and you just keep quiet and you continuously do it, and you could raise fear in the other party, and the House of Lords was convinced that indeed this action amounted to the actus reus of assault, and indeed it amounted to an assault. We have already talked and said that an assault can be created by words alone, as long as they can cause the victim to fear the infliction of unlawful force on his body. We already gave an example, and there are so many examples that can show this. For example, if a man shouted to a stranger that I'm going to kill you, okay, just the mere shouting, okay, and you tell someone that I'm going to kill you, that alone indeed is an assault to the other person. We already talked of raising a pistol, pointing it at a person. All those acts, provided the act is able to create fear, okay, reasonable apprehension of fear in the other person, then the same could amount to an assault. Also, I invite you to look at another interesting case of R versus Ireland and Basto. It's a case of 1997, QB page 114. It's also reported in Queen's Bench, 1996, volume 3. You'd also be able to find that case at page 650. And also you can find it in the weekly law reports. Now, in that case, the House of Lords stated that silent phone calls, again, the court is insisting, that silent phone calls would amount to an assault. So this is very, very important to note. So let's proceed, ladies and gentlemen, to look at the mens rea of assault. Remember, we said mens rea simply means a guilty mind. Do not forget that there cannot be a complete offense if both actus reus and mens rea are not in place. Of course, the exceptions are for strict liability offenses, which we'll be looking at later in another class. But for this other class of offenses, for an offense to be complete, there must be an actus reus, which is the guilty act. Then there also must be the mens rea, which is the guilty mind. So let's proceed now to look at the mens rea of the offense of assault. Now, the mens rea for assault is if the accused intends the victim to fear the immediate infliction of personal violence, or he or she recklessly foresees that the victim may do so. Thus, a threat to harm at a future time can never amount to an assault. Now, this is very, very important. The mens rea here is the moment you intend, okay, to create that fear, okay, of violence or infliction of harm on the other person. Or even if you don't intend, but your actions are done in a reckless manner, okay? Remember, recklessness, okay, and negligence, these are vital elements of mens rea. The moment a person acts recklessly, okay, then they have a guilty mind. The moment someone acts negligently, or their actions done wantonly, then all those actions or those elements point to a guilty mind. So the moment you do something recklessly and it ends up having an implication on the other party, then definitely in this context that would amount to an assault. But a threat, okay, for future harm does not suffice. Okay, for example, if I threatened you and I said, next year in December, I promise that I will beat you up. Okay, definitely such threats of future harm can never amount to a satisfactory mens rea, and they do not suffice in such circumstances. I also encourage you again to look at the case of R versus Constanza. It's a case of 1997, CLR, page 576. This case is again authoritative, and it involved stalking, and court confirmed that words again could amount to an assault. Of interest as well, look at the case of Smith versus Chiefs Superintendent Working Police Station. It's a case of 1983, criminal appeal, page 323. Now, in this case, a lady was at home on the ground floor apartment, dressed only in her nightdress. She was terrified when she suddenly saw the accused standing in the garden staring at her. Court found him liable for assault on the ground that the victim feared immediate infliction of personal violence, although she was safely locked inside. So again, you're seeing here how the court would interpret certain actions as to amount to an assault. So someone is dressed in a nightdress, locked up inside the house, but the accused was actually standing outside, staring at them. Okay, but even if actually the accused could not have reached out to the victim because they were safely locked inside the house, but court still held that the same amounted to assault because it created that fear in the victim's person. So for an act or threat or words to amount to an assault, it's also very important to note that the same must be unlawful. So all those actions, you charge towards someone, you threaten someone, provided they create that fear into that person, then such actions can be safely stated to amount to an assault. So let's look at a number of cases on top of those that I've shared with you on the principle of assault. I encourage you to look at the case of Uganda versus Bonga and two others. This is a criminal appeal number 5 of 2015. And in this case, basically, court was examining the third ingredient of the offense, which I already discussed for you. And in this case, court held that that is the third ingredient, is a minor and cognate offense. The offense of assault is a minor and cognate offense for which proof of actual bodily harm is not a necessary ingredient. This we had already highlighted, that in assault it is immaterial for you to prove actual bodily harm. So there needn't be actual bodily harm on the person for them to succeed or for us to say that there has been assault. That is very important to note at that juncture. So, ladies and gentlemen, that is it basically on this offense of assault. Thank you very much for listening into this class. And again, I encourage you to subscribe to this channel. Also turn on your notification, like and share with your friends. And also always contact us in case you have challenges in class, and we can always give you that polish, that touch with our private legal services. It's always very important for a student to be properly mentored so that you're able to understand these legal principles very well. Thank you very much. We meet once again in another class where I'll be taking you through the other offenses. Bye-bye. See you next time.